Case number C-17-141, State of Washington versus Donald J. Trump.
The order is illegal and is causing serious immediate harms to our states, to our state institutions, and to our people. And enjoining the order is overwhelmingly in the public interest. I'm not aware of any executive order quite like this one, that there's so much evidence before there's even been any discovery that it was motivated by animus, religiously targeted, and just utterly divorced from the stated purposes of the order.
It seems to me that it's a bit of a reach to say the president's clearly anti-Muslim or anti-Islam based on what he said in New Hampshire in June.
We have the president's advisor saying on national television that the president asked him to come up with a Muslim ban. This was after the election. Asked him to come up with a Muslim ban in a way that would make it legal, and that's what they did. And so
does the executive order mention the word Islamic or Muslim?
It does not. But when we're arguing about religiously motivated targeting, again, the burden is not to prove that it affects every single person of the Islamic faith. The burden is to prove that a desire to discriminate based on religion was one motivating factor in the adoption of the order. No discovery, and there's already an overwhelming amount of evidence to suggest that that's the case, that it was at least in part motivated by religion. Part of the evidence of that, Your Honor, is that the tie to the stated purposes of national security is so tenuous here. I mean, the president apparently had not decided whether the order applied to lawful permanent residents before it was issued. And there's roughly 500,000 lawful permanent residents from these 7 listed countries in the United States. Either those people are an enormous threat to our safety or they're not, and they've changed their mind about that 5 times since Friday. First they said that it did apply to them, and many of those people were excluded from returning to the country. Then they said, and the Department of Homeland Security reiterated that it applied to them. Then the Secretary said that it didn't, and then the White House spokesperson said it did not, and then the White House counsel has now issued authoritative guidance, whatever that means, that although there could have been reasonable confusion about what the order meant, it wasn't meant to cover those people. So the point is, if they were an enormous security risk, you would think that they would have made up their mind about that before issuing the order.
What do you say to the argument that the 7 countries that were designated, and I'll quote the language, have been designated as, quote, countries the government of which has repeatedly provided support for acts of international terrorism under 8 U.S.C. 1187. Wouldn't that provide a rational basis for the executive order?
Your Honor, that would provide a cover, in our view, for that was maybe one motivating factor. But when you look at the standard of proving a religious discrimination claim, again, you can't just accept at face value the stated purposes. The president's action here is not endorsed by Congress. It's not consistent with congressional directives. It is actually contrary to what Congress has said about how these sorts of decisions are supposed to be made, which further undermines the federal government's argument for deference to the president's decision-making in this context. The Establishment Clause, one of the original purposes of it was to protect the states against the federal government choosing a national religion and imposing it on the states. So the idea that the state would not have standing to challenge a national government, the president anyway, expressing a preference, is just, it makes no sense. And again, I can't cite you to a case where a state sued the federal government over an Establishment Clause violation, but I also can't cite you to an executive order ever before quite like this one, or the circumstances that we are facing today. Frankly, the federal government's position about the standard of review here is frightening. I mean, they're basically saying that you can't review anything about what the president does or says as long as he says it's for national security reasons, and that just can't be the law.
Bennett, are you arguing?
Yes, Your Honor.
Thank you for coming. I thought your brief was extremely well done. It was helpful.
Thank you, Your Honor.
Your Honor, for some of the reasons we mentioned, we think we have very good reasons why the state is not likely to prevail on the merits, but I'd like to start with standing, which I think distinguishes this case from some of the other cases that have been filed around the country.
Let me stop you. In the state of Washington, I can't speak to Minnesota, but both the University of Washington and Washington State are considered parts of the state government, and they've cited a litany of direct consequences, damages to them. Given the breadth of authority of the executive in the area of immigration, do you acknowledge any limitation on his or her power?
Your Honor, I don't think Your Honor needs to answer that question to decide on this case.
No, but it seemed like a good question.
Given, I don't think it would be wise to sort of opine on what the extent of the executive's power is. I mean, I think here we have specific circumstances where the President has issued this executive order. It was pursuant to authority that Congress gave him in Section 212F of the INA that specifically allows him to suspend the entry of certain aliens or a class of aliens when he finds that it would be detrimental to the interests of the United States to allow them in. So here we have the President acting pursuant to power that Congress gave him, which means under the Youngstown still seizure cases, he's acting at the apex of his power. And so we think in the context of, certainly in the context of this case, the President is acting well within the authority that Congress has given him. And Your Honor need not opine on what he may or may not be able to do beyond that.
The rationale for Section 3 is invoking 9/11. And my question to you is, have there been terrorist attacks in the United States by refugees or other immigrants from the 7 countries listed since 9/11?
Your Honor, I don't know the specific details of attacks or planned attacks. I think I will point out first of all that the rationale for the order was not only 9/11. It was to protect the United States from the potential for terrorism. I will also note that the 7 countries that are listed in the executive order are the same 7 countries that were already subject to other restrictions in obtaining visas that Congress put in place, both by naming countries, Syria and Iraq, and that the prior administration put in place by designating them as places where terrorism is likely to occur, or the specific factors are whether the President's presence in a particular country increases the likelihood that an alien is a credible threat to U.S. security or an area that is a safe haven for terrorists.
Well, let me walk you back then. You're from the Department of Justice, if I understand correctly.
Yes.
So you're aware of law enforcement. How many arrests have there been of foreign nationals for those 7 countries since 9/11?
Your Honor, I don't have that information. I'm from the Civil Division, if that helps get me off the hook any.
Well, let me tell you, the answer to that is none, as best I can tell. So, I mean, you know, you're here arguing on behalf of someone that says we have to protect the United States from these individuals coming from these countries, and there's no support for that.
Your Honor, I think the point is that because this is a question of foreign affairs, because this is an area where Congress has delegated authority to the President to make these determinations, it's the President that gets to make the determinations, and the court doesn't have authority to look behind those determinations. They're essentially like determinations that are committed to agency discretion.
Counsel, I understand that from your papers, and you very forcefully presented that argument. But I'm also asked to look and determine if the executive order is rationally based. And rationally based to me implies that to some extent I have to find it grounded in facts as opposed to fiction.
Well, Your Honor, we actually don't think you are supposed to look at whether it's rationally based. We think that the standard is, again, facially legitimate, and that there are some cases that say the court would have to find it wholly irrational. And again, Your Honor, I would point to the fact that Congress itself has specifically designated 2 of these countries as areas of concern with respect to terrorism, and the Obama administration, the executive branch, designated the remaining 5. And so it's not that this executive order is in that regard saying anything new about these being countries of concern as it regards to terrorism. And then we would just point to the balance of the equities, Your Honor, and note again that in this regard the President was acting pursuant to congressional authority at the height of his power in the area of national security, foreign affairs, and immigration. So we'd ask that Your Honor deny the TRO.
All right, thank you.
Thank you.
I'm going to digress for a moment and remind people who see this opinion and wonder what's going on. Fundamental to the work of this court is a recognition that it is only one of 3 branches, 3 equal branches of our government. The role assigned to the court is not to create policy, and it's not to judge the wisdom of any particular policy promoted by the other two branches. That is the work of the legislative and executive branches, and the citizens who ultimately, by exercising their rights to vote, exercise democratic control over those branches. The work of the judiciary is limited to ensuring that the actions taken by those two branches comport with our laws and, most importantly, our Constitution. There is a very narrow question before the court today that it asked to be considered, and that is whether it is appropriate to enter a TRO against certain actions taken by the executive that are enumerated in this specific lawsuit. Although that question is narrow, the court is mindful of the considerable impact that its order may have on the parties before it, the executive branch of our government, and the country's citizens and residents. The court finds that for purposes of the entry of the temporary restraining order, that the state has met its burden of demonstrating that it faces immediate and irreparable injury as a result of the signing and implementation of the executive order. I find that the state has satisfied the test that it is likely to succeed on the merits of the claim, which would entitle them to relief. I find that the balance of equities favor the states. And lastly, I find that a temporary restraining order is in the public interest. As such, I find that the court should and will grant the temporary restraining order. The court concludes that the circumstances that brought it here today are such that we must intervene to fulfill the judiciary's constitutional role in our tripart government. Therefore, the court concludes that entry of the above-described TRO is necessary, and the state's motion is hereby granted. Counsel, anything further at this time? Mr. Purcell? Ms. Bennett?
One more thing, Your Honor. As a procedural matter, the government would move, Your Honor, to stay the TRO, the same purposes that we oppose the TRO, pending a decision by the SG of whether to appeal, to file an appeal.
I'm sorry, pending a decision by the...
By the Acting Solicitor General. I'm sorry, Your Honor. We use lots of acronyms.
Yes.
By the Acting Solicitor General.
I understand the motion, and I'm going to deny it.
Thank you, Your Honor.
I will do everything I can to get you prompt appellate review, which I think is the appropriate case to take.
Thank you, Your Honor.
We will be in recess. Thank you, counsel.
It's obviously a historic decision and an important one for the rule of law and for the people of the state of Washington and the people of our country. I said from the beginning, it is not the loudest voice that prevails in a courtroom. It's the Constitution. And that's what we heard from Judge Robart today. I want to be very clear about what his decision does. And then I'll turn to Noah Purcell, my Solicitor General, who will add a few comments as well. Judge Robart's decision, effective immediately, effective now, puts a halt to President Trump's unconstitutional and unlawful executive order. I want to repeat that. It puts a stop to it immediately, nationwide. The law is a powerful thing. It has the ability to hold everybody accountable to it, and that includes the President of the United States. I do want to thank businesses like Expedia and Amazon, who really stepped up. Last weekend we were putting together our motion and our complaint. They filed declarations of support, which helped demonstrate the harm done to Washingtonians individually, but also to Washington businesses as well, and to their employees. So it's been a team effort. I'm proud to lead this team that again has demonstrated the power of the law in holding everybody in our country accountable to that rule of law, including the President.